Module Summary. Informed consent and capacity assessment are cornerstones of ethical healthcare practice. They are the gateway through which patients exercise autonomy, choice, and control over their health data and treatment. This module explores the deep ethical, legal, psychological, and procedural dimensions of informed consent and mental capacity, especially as they relate to confidentiality and data sharing. You will investigate what constitutes valid consent, how to assess whether a patient has capacity to consent or refuse, and the processes to follow when patients lack capacity, including substitute decision-making, best interest standards, and the use of advanced directives. 1. What is informed consent? Informed consent is a process, not just a signature, that ensures patients understand the nature, risks, and benefits of a procedure or data disclosure, voluntarily agree to it without coercion, have the mental capacity to make the decision. Key elements: information. Patient must receive all relevant details in clear, non-technical language. Comprehension. They must be able to understand and ask questions. Voluntariness. Consent must be free from pressure or manipulation. Decision-making capacity. The patient must be able to understand, retain, and weigh information. 2. Types of consent in healthcare. 1. Type 2. Description, explicit consent. Clearly expressed, oral or written. Required for sharing identifiable data under GDPR, implied consent. Assumed through patient actions, e.g. offering arm for blood draw. Not suitable for sharing sensitive data. Informed consent, fully explained and voluntarily given. Highest ethical standard. Proxy/surrogate consent, given on behalf of a patient who lacks capacity by guardian or legal substitute. Advanced directives, instructions made in advance about care or information sharing, should capacity be lost later. 3. Consent and confidentiality, the legal link. Under GDPR and healthcare law, personal data, including health records, can only be processed or disclosed with a lawful basis, and often explicit consent. However, consent is only valid when it is freely given. It is specific, informed, and unambiguous. The patient has the capacity to give it. It can be withdrawn at any time. Consent is not valid if the patient is misinformed or deceived. It is coerced. It is obtained under duress. Capacity is absent. 4. Assessing capacity to consent. Mental capacity is the ability to make decisions at a specific time. According to the UK Mental Capacity Act 2005 and Canadian standards, a person is assumed to have capacity unless proven otherwise. To assess capacity, evaluate if the patient can understand information relevant to the decision, retain that information, weigh the information as part of decision-making, communicate the decision by any means, temporary incapacity, e.g. unconsciousness, delirium, intoxication, may still require later reassessment. When a person lacks capacity, decisions must be made in their best interest. Consider advanced directives, appointed representatives, or legal guardians. 5. Refusing consent and confidentiality. Patients have a right to refuse consent for data sharing, even if that seems unwise. Ethically, the refusal should be explored gently through discussion, respected if the patient has capacity. However, refusal may be overridden. In life-threatening emergencies, when public safety is at stake, if required by law or court order, in all cases, document thoroughly, use the least intrusive disclosure. Notify the patient whenever possible. 6. Children and consent. In many jurisdictions, children can give consent if deemed competent. Gillick competence in the UK. Children who understand the implications of a decision can consent. Parental consent is needed only if the child lacks competence. In all cases, data sharing must respect the child's confidentiality unless risk of harm exists. 7. Best interests and substitute decision makers. When capacity is lacking, a legally appointed substitute decision maker (SDM) may consent. Healthcare teams must assess what is in the patient's best interest, factoring medical benefit, known wishes, religious and cultural beliefs, comfort and dignity, family and social impact. In the UK, Court of Protection may intervene. In Canada, public guardian or legal proxy may apply. Globally, frameworks must respect both human rights and data privacy laws. 8. Documentation and audit readiness. To ensure compliance and quality care, use consent forms for treatments and disclosures. Record capacity assessments clearly. Note any disagreements, refusals, or special risks. Retain advanced care planning documents. Auditable records must show consent given or refused, who provided the consent, capacity was assessed. Alternative options were discussed,